But, well, she witnessed the Australia Act.
Which Governor-General was it at that time?
Hayden, was it? Yeah.
Hayden's deputy.
Yeah. Yeah. So Bob Hawke again proposed Bob Hawke was part of the process of putting the question to the people in 1984, and Bob Hawke's government then ignored that referendum. Okay, ignored the referendum. So under section 44I of the Constitution, basically what's happened from 1986 is now our governments, federal, state and local, have an allegiance to a foreign power. Now, when I read section 44I, my interpretation of that is I see foreign powers as political parties. Okay, because nowhere in here is there a mention of a political party.
Except in
Except in section 15, under casual vacancies of the Senate, and that was slipped in 1977. One of the 6 referendums that actually went through, they managed to get political party into section 15.
Shouldn't have been held.
Should never have been held, and in fact it can be challenged on the basis that there is still no annotation existing. Now, we all understand what the word annotation means. It means a breakdown of those 2 words. Okay, we require a full breakdown of those 2 words. It is still not being done with respect to this Constitution. Now, there is a 1,000-page document called the Quick and Garran, which is an annotation of our Constitution as of Federation.
When they go for a referendum, ask everybody who has to vote for or against, aren't they obliged to explain to us why they want a referendum?
That's the yes and no vote. That's the yes and no thing.
Yeah.
Well, yes or no, if I don't know what to write...
So you stand in the safety zone and just vote no. I mean, it's crazy. One of the biggest problems, from my interpretation of our Constitution and all the referendums that have taken place since 1900 is, our governments have not known really how to deal with this thing called a referendum. Because it is a stranger in England, it is a stranger within the Commonwealth. Australia is the only country in the Commonwealth who has a referendum clause in it. We took it from the Swiss Constitution. The thing is, the government here either too afraid. Now, there is a 1,000-page document called the Quick and Garran, which is an annotation of our Constitution as of Federation.
When they go for a referendum, ask everybody who has to vote for or against, aren't they obliged to explain to us why they want a referendum?
That's the yes and no vote. That's the yes and no thing.
Yeah.
Well, yes or no, if I don't know what to write...
So you stand in the safety zone and just vote no. I mean, it's crazy. One of the biggest problems, from my interpretation of our Constitution and all the referendums that have taken place since 1900 is, our governments have not known really how to deal with this thing called a referendum. Because it is a stranger in England, it is a stranger within the Commonwealth. Australia is the only country in the Commonwealth who has a referendum clause in it. We took it from the Swiss Constitution. The thing is, the government here either too afraid, or when they do put a question to us, they put it in such a way that we fall back in the safety zone.
Yeah.
We need to really, by understanding our laws, we have the ability, through Section 128, to put a question to the Governor-General with respect to conducting a referendum. We can do that. We petition the Governor-General.
The ability also we've got to pass people to do it.
Yeah,
No.
we do. Absolutely.
Incidentally, I have sent 1,100 signatures for de-amalgamation. That's all I knew when I first came here. I took it back to the people that I know in the bush, and I've got 1,100 signatures for the amalgamation. I still got the big Hansard, whatever it's called.
Yeah.
I've got the copies. All the people, they asked me, said, what next? I said, the only thing I can think of is an association. Would that be better? Because the government didn't take any notice of us with the objection we were against the amalgamation.
Yeah, well, that's where petitions don't have legal power with respect to an instruction specifically against the government. It has to be done in the form of a mandate. And then they'll do it.
I've still got all the names and addresses and telephone numbers.
Yeah, but then each individual would have to be reapproached, and they would have to sign an individual form obligating them, showing their name, their address, signature, date, with respect to that specific instruction. And what you're doing is you're saying, I'm expressing my will. Individually. So that's your sovereign right to do that. And it's expressed as such. But we cannot be expected to impose that on a private corporation. Okay, we can only do that with respect to our elected governments. Okay, so if it can't have the wording in there with respect to a corporate body.
If we're trying to get a mandate and have a majority, what's the basis of the majority? Because obviously it's not practically fit a majority of a whole state.
Yeah, whenever I've gone and done one or helped draft one, I've been only comfortable when I've seen over 90% support for the particular.
How do you put a boundary around 90%? 90% of what?
The affected area.
So it doesn't have to be a seat parliament?
No, it's like, for instance, where I did help was the toxic waste dump. So the people in that affected area, there was full support in that area. So then I was able to come in and help draft it.
How do you separate yourself from an elected government to elected corporate government? So we are electing corporate government, which is in power.
Yes.
So how do you then chuck the corporate government out and put an elected government?
By telling as many people as possible about their constitutional rights, and the political parties don't legally exist in this thing, and the only people who are recognised under the Constitution are independents. Okay? There's no such thing as because how can my elected representative have a foreign power in between him or her and me, the constituent? There can't be that. That's why 44I was drafted, Jim.
They become intermediaries.
Well, the thing is, well, this is something. This is one thing that we haven't done for the last 100 years, is fully empower this, not only with our knowledge but our Parliament's will as well. They haven't operated this. They've been trying to step away from this. We haven't had a chance to see if it works. From all reading, it will work, but it relies on our knowledge of this. It really relies on the people feeding back to their elected representative. It will work then. This thing only required Parliament to sit 3 times a year. I really can't see why it should sit full time.
Yes, right.
The rule of law is what we're all obedient to, including them. The thing is, they, as a public servant, are obedient to us.
You're not public servants, not representatives, not public servants.
I mean, finer the definition is of mandate. As the years have gone on, they've been stepping away from it, and they've been putting a different definition on mandate, as we've been hearing, especially every election.
Yeah.
It's incorrect. You cannot broadly sweep your definition of mandate over many requirements. Mandate is specific to one action. and one action only.